Most people who carry debt, and most people approaching retirement, do carry some form of it. Hold a version of the same quiet fear, not about the debt itself, about what it does to the people they leave behind. It's not a fear most people say out loud. It surfaces at odd moments. When you're updating a beneficiary form, when a friend mentions their spouse died and left things complicated, when you lie awake doing math that doesn't quite resolve. And the reason it doesn't resolve is that almost no one has ever explained what actually happens to debt when someone dies. Not in plain English. Not for your specific situation. Not in a way that actually answers the question. That's what today is. By the end of this video, you'll be able to sort every debt you currently carry into one of 3 categories and know, for each one, exactly what happens to it, who is responsible, and whether it requires any action from you before that day comes. The fear doesn't go away because you ignore it. It goes away because you understand it. So let's start there. So let's talk about the 2 stories most people carry about debt and death, and why both of them are wrong in ways that cause real harm. The first story is the one that generates the most fear, that when you die, your debts transfer directly to your family, that your children will inherit your credit card balance, that your surviving spouse will be on the hook for every bill you left behind, that the collectors will come and your family will have no choice but to pay. That story is largely false. And if you've been carrying it, you can put some of it down right now. The second story is the one that generates a different kind of problem, that debt simply disappears at death, that it's not worth thinking about, not worth planning around, not worth mentioning to anyone. That story is also false. And the people who believe it are sometimes the ones who leave their families in the most complicated situations. The truth lives between those 2 stories, and it's actually more navigable than either one suggests. But it requires understanding one thing that almost no financial content ever explains clearly. Debt does not behave the same way across all categories. The rules that govern what happens to a credit card balance in your name only are completely different from the rules that govern a mortgage, which are completely different from the rules that govern a loan you co-sign for your adult child. There are 3 categories. And once you know which category each of your debts falls into, the picture stops being a fog and starts being a map. That's what this gap in, not your knowledge, that's a gap in what anyone ever required to explain to you. So let's fix that now. Let me walk you through how debt actually works when someone dies, because this is where clarity replaces fear. Category 1. Sole unsecured debt. This is debt in your name only, with no collateral attached to it. Credit cards you opened yourself. Medical bills. Personal loans with only your signature. When you die, this debt does not transfer to your children. It does not follow your family. What it does is make a claim against your estate, the pool of assets you leave behind. Here's what that means in practice. Your estate, whatever you owned, goes through a legal process called probate. During that process, creditors are notified and given a window to file claims. The estate pays what it can, in a specific legal order of priority. If the estate doesn't have enough to cover everything, and many don't, those unsecured debts are discharged. Gone. Not your children's problem. The Consumer Financial Protection Bureau is clear on this. Family members are generally not legally obligated to pay the debts of a deceased relative from their own money, unless they were joint account holders or co-signers. Collectors who imply otherwise are operating outside the rules. That last sentence is worth sitting with for a moment. Because collectors do sometimes contact surviving family members, and grieving families sometimes pay debts they were never legally required to pay, because no one told them they had the right to ask for documentation of the obligation. Now, Category 2, secured debt. This is debt attached to a specific asset, most commonly a mortgage or a car loan. The debt and the asset are connected. If you die with a mortgage on a home, the debt does not disappear. But it also does not automatically become your family's personal liability. What happens depends on what your family does with the asset. If a surviving spouse or heir wants to keep the home, they will generally need to continue making payments or refinance the loan. If no one wants to keep it, the home can be sold, the mortgage paid from the proceeds, and any remaining equity goes to the estate. The home doesn't disappear. The debt doesn't disappear. But the obligation follows the asset, not the person. Category 3 is the one that requires the most attention. And it's the one most people don't think about until it's too late to plan around. Which brings us to the situations where debt actually can directly affect the person you most want to protect. Joint accounts, co-signed loans, and if you live in certain states, community property rules. A joint account holder is not the same as a beneficiary. This distinction matters enormously, and almost no one explains it before it matters. If you and your spouse have a joint credit card, both names on the account, both legally responsible, then yes, when one of you dies, the other remains fully responsible for that balance. Not because debt transferred, because you were both always on the hook. The same is true for co-sign loans. If you co-signed a car loan for your adult child, or if your adult child co-signed something for you, the co-signer does not get released from that obligation at death. The surviving co-signer becomes solely responsible. This is the part the fear was actually pointing at, not the credit card in your name only, not the medical bills from last year, the joint account, the co-signed loan, the structure you set up for convenience or out of love that has legal consequences you may not have fully mapped. Now, community property states. If you live in Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, or Wisconsin, the rules are different for married couples. In community property states, debts incurred during a marriage are generally considered the responsibility of both spouses, even if only one name is on the account. Which means a surviving spouse in a community property state can, in some circumstances, be held responsible for debt that was never in their name. This is not a reason to panic. It is a reason to know which state you live in and to factor that into any estate planning conversation. Here's the reframe that matters. The fear most people carry about debt and death is not irrational. It comes from a real place, a real uncertainty about what you might leave behind for the people you love. But that fear was aimed at the wrong target. The credit card in your name only, probably not the problem. The medical bills, probably not the problem. The joint account you haven't reviewed in years. The co-signed loan you said yes to without fully reading the terms. The community property rules in your state that no one mentioned when you set up your accounts. Those are the things worth looking at. And now you know exactly where to look. Here's something this video can't do for you. And it's the step that matters most after the understanding lands. Knowing what happens to your debt is one thing. Having the actual conversation with your family about it is another. Most people skip that second step. Not because they don't care, but because they don't know how to start it without it feeling heavy or final, or like an admission of something they're not ready to say out loud. The retirement money conversation guide in the description was built specifically for that moment, with real scripts for the conversations most families avoid, including this one. The link is in the description and in the pinned comment. So what do you actually do with this information before it becomes urgent? Let me show you the simplest next step. Start with an inventory. Not a comprehensive estate plan, not a legal document, just a list of every debt you currently carry, and next to each one, the category it belongs to. Sole unsecured debt in your name only. Category 1. Claim against the estate. Family not personally liable. Mortgage or secured loan. Category 2. Follows the asset. Heir decides what to do with it. Joint account, co-signed loan, or community property state obligation. Category 3. Requires attention. Requires a conversation. That inventory will probably take you 30 minutes. And it will tell you more about what actually needs your attention than anything you've been worrying about in the abstract. For most people, the majority of their debt will fall into categories 1 and 2. The estate handles it. The family inherits what's left, or nothing if there's nothing left. But they do not walk away personally responsible. For some people, category 3 is real and present. A joint card with a significant balance. A co-signed loan that was never revisited. A mortgage in a community property state. If category 3 applies to you, there are specific things worth doing, not urgently, not in a panic, but before this becomes someone else's problem to sort out while they're also grieving. Review which accounts are joint and which are individual. If there are joint accounts you could convert to individual ones without disrupting your household, that's worth knowing. Review any co-signed obligations. If the original reason for the co-sign no longer applies, if the loan can be refinanced without your signature, that conversation is worth having now, not later. And if you are in one of those 9 community property states, a single conversation with an estate attorney, not a financial advisor, an attorney who handles estates, will give you a clear picture of how your state's rules apply to your specific situation. This is not about having a perfect balance sheet when you die. It's about not leaving confusion where clarity was possible. Because here's what nobody explained before you needed to know. The burden families carry after a death is almost never the debt itself. It's the uncertainty, the not knowing, the box of unopened statements, and the question of what any of it means. What you can do right now, before any of this is urgent, is make sure that box doesn't exist. If today opens something you want to go further with, specifically the question of how to actually talk to your family about this, the resource in the description is the next step. That conversation doesn't have to be heavy, it just has to happen. What's the money conversation you've been putting off with your family? And what's made it hard to start? So here's what's different now. You arrived at this video carrying something vague. A fear that lived in the general direction of debt and death but didn't have a shape you could work with. What you have now is a framework. 3 categories. Clear rules for each one. A specific, short list of the situations that actually require action, and the much longer list of situations that don't. Most of what you've been worrying about will not follow your family. It will make a claim against your estate, get paid what it can, and dissolve. A smaller set of things. The joint accounts, the co-signed loans, the community property rules if they apply to you, those are worth a clear look. Not because they're emergencies. Because they're the kind of thing that's easy to address when you're here, and very hard to untangle when you're not. There's a version of what you leave behind that your family will spend months sorting through. Not because you didn't love them, but because you didn't know where to look. And there's a version where they know. Where the accounts are labeled. Where the conversations happened. Where the uncertainty was replaced, not with a perfect plan, but with enough clarity that they don't have to guess. That second version doesn't require a lawyer. It doesn't require a financial advisor. It requires 30 minutes with a piece of paper and the willingness to look at the list. You now know what to look for. That's not a small thing. That's one less thing to carry into this next chapter. One less thing.